Ladies and gentlemen, I am honored to have the possibility to share with you some thoughts on the relation between the public and the private sector. As Mr. Bernasconi already mentioned, I am from the other side as well. And this is good so, as a German politician said. What I mean is, I represent today the private sector. My name is Franz Kummer. I work in both sectors in a private business company. This is the major part of my work, and in the public sector at the University of Bern. My speech does not pretend to discuss the exact legal conditions of the relationship between private and public sector, but it simply tries, as the title suggests, to share some thoughts on this topic, which means to inspire some reflections. I would like to talk to you about the doubts or the fears of some players of the private sector. Therefore, I would like to start with some selected examples, even there are many more cases that would merit to be mentioned in this place. A recent example from yesterday is the discussion between publishers and the Swiss radio and television company. The publishers demand free access to the content that is already paid by some special sort of taxes. I don't want to value or judge these examples. For the moment, they are just facts. My main point is the question of defining what the public sector can and should do, what the role of the private sector is, and how to set clear boundaries or limits between the two. From the point of view of the private sector, it is problematic when public institutions act on the market or offer products that are competing with privately developed solutions. The private investments are not protected enough, which has a negative impact, or could have a negative impact, on the innovation. My first example is the Swiss Federal Tribunal, the highest court in Switzerland. The Federal Tribunal is present on the market with two products, Open Justitia and an expert search. Open Justitia is an open source software with 6 modules. An OSS community with the same name exists, gathering 16 institutions and private companies. The problem is the majority of these modules were already existing on the market. The Tribunal Federal has developed its products itself, in-house, instead of acquiring them on the market, and is now making them accessible to the community and to all interested organizations or private companies. Many similar products are already on the market, which means that we have publicly funded software that compete with many private companies. The impact on the market is, in this case, significant. On the other side, the Swiss Federal Tribunal is publishing its decision. And that's not very special. One part of the database is free accessible. I call it the basic version or basic services. It's including the publication of the decisions, news, and a search engine. Another part of this project, the so-called expert search, is only accessible behind a paywall. The expert search includes more information, which means intellectual input and preparation of important decisions. The important legal articles and keywords are specially named. Further, they offer personal profiles for the search and for email notification. In this second example, we have a separation between basic services, that means public sector, and refining or enhancement, that means private sector. The problem is, also in this field, similar products are already on the market, which means that the public sector is in competition with the private one. The target audience for this expert search are law students, universities, attorneys, lawyers in different positions and practice areas. This is certainly not a service to fulfill a basic informational need of the citizens, but a classic business-to-business service. The online platform of the State Secretariat for Economic Affairs, the SECA, for small and medium enterprises is also an interesting example. The website publishes a wealth of good and interesting informations and examples, especially relative to startup companies. It is clear that this is not only a basic service, the informations were intellectually prepared for the publication. This website is in competition with attorneys, notaries, as well as councils and publishers or simple bookstores. The same applies to the services offered by the District Court of Zurich. The website offers many informations, sample documents, and templates for free, whereas these services should normally be acquired on the market, and the market is a little bit the same: attorneys, notaries, councils, publishers, and bookstores. What we see here is the classified compilation of the Swiss federal law, the work of Michel Moret. The official compilation, Amtliche Sammlung, and the Federal Gazette, Bundesblatt, were accessible as well. The question remains the same: what should be offered? Some keywords here are just the basic texts, historical texts, a search engine, some registers and indexes, or a non-official English version of the legal text, a citizen account with a password, with profile search, personal notes in the cloud, alert systems. Should the government produce a free of charge app? What other Web 2.0 gadgets would make sense? Or other improvements like, for example, automatic or semi-automatic hyperlinks to the decisions of the Federal Tribunal, which decisions were published concerning a specific legal act or a specific article within a given lapse of time, and so on. There are practically no limits to new features and improvements. But the question remains: what should and can do the public sector, and what is the role of the private sector? So, let's get one step back from these examples to the legal and a few arguments or just thoughts. The public sector and the private sector in Switzerland know a division of tasks. They provide different kinds of services. The public sector can act on the private market only in exceptional cases. This is defined by the principle of economic freedom, contained in the Article 94 of the Federal Constitution. The Confederation and the cantons shall abide by the principle of economic freedom. Any divergence from the principle of economic freedom, and in particular measures designed to restrain competition, shall be permitted only if they are provided for in the Federal Constitution or based on cantonal monopoly rights. Other important rules are contained in the Articles 41 and 41a of the Federal Act on the Federal Financial Budget, Finanzhaushaltsgesetz. The Article 41 says that administrational units can only provide commercial services for third parties if an act allows them to do so. The Article 41a provides a few exceptions to this rule. Important is Part 3. The commercial services should be provided for a price that at least covers the costs. The department in charge can allow exceptions to this rule if this does not lead to a situation of competition with the private sector. In the domain of electronic publication of legal data, there was an ordinance which is not in force anymore. The name was Ordinance on the Electronic Publication of Legal Data. One of the main points of this ordinance was the publication of legal data as well as important supporting services such as registers, indexes, and full-text search is provided by the public sector. Enhancement, refining, on the other point, is reserved for the private sector. Part 2 was naming a few exceptions. How was this separation between basic services and refining enhancement understood? The consensus about 10 years ago was everything that can be reached by the state of technology would fall into basic services. Everything that needed intellectual input would be treated as enhancement. These enhancements would be left for the private sector. But what means state of the technology? The understanding of this term changes with the advance of the technology. Problems that required a substantial amount of work a couple of years ago can now easily be solved. What you see there is on the left side the basic services. That means the public sector, Grundversorgung. On the other side, you can find refining enhancement. That means the private part. Somewhere in between is located a line. It is a limit or a border. I call it the state of technology. In the line below shows the possibilities. Products, features, ideas, and so on. The border, state of technology, is in a constant movement. The line is never moving back. Everything on the left side on this line is in the public sector. This part grows. The line knows just one direction, and this is the direction of the private part. And this part is getting constantly smaller and harder to enlarge or extend. The farther one goes to the right, the more the costs and the risks are rising. From an economic point of view, it is very important to know the place of the line or this border. You need to have legal certainty or legal security and a sort of investment protection. It is clear that the public and private sector do not share the same objective. The public sector informs the citizens. The law is complex, a complex topic, and the public sector tries to make it accessible and uncomplicated to citizens or companies. The private sector needs to be profitable. It has to offer good services to bring added value to the customers for which they are willing to pay for. The starting point and the financial possibilities are very different. Whereas the private sector has to follow the balance of the offer and demand, the public sector can dispose of much bigger amounts of financial means. Practically, it means that in this very specialized niche, the private sector does not have any chance. Notwithstanding this fact, the entrepreneurial innovation is very important. Being an entrepreneur means taking risks, but it becomes problematic if the legal certainty is not guaranteed and the investment is not sufficiently protected. It makes an enormous difference if I compete with other private companies that have to finance their products just as I do, or if I compete with the public sector. From the private sector point of view, the most important thing is the possibility to foresee and anticipate future developments in order to calculate the risk correctly. That means, where are the limits between the players? One possibility to consider would be to have the public sector offer less products and solutions, but give access to more data. Keyword is open data. There already is an open data portal in Switzerland, but only very few legal data has been published there. Well-structured data would help create a lasting ecosystem that would foster private innovation. I would express it like this: creating possibilities, not products or solutions. Another consideration would be to ask, who is this service aimed at? Business to business or business to consumer is competition needed? What objectives are achieved with this service? Make it easier for the citizen to access the law or the tribunal, support the work of an attorney, means a businessman, or compete with this attorney. It does not make sense if an administration unit develops a solution in-house when this solution is already available on the market. For example, the Tribunal Federal with Open Justitia and the expert search. Such solutions are already on the market. The clients are business to business, private company can access these new solutions. This is a direct competition for the other private companies that invested money in the development of the products. From the point of view of the private sector and maybe the national economy in general, it can make more sense to share the tasks. A lean and business-friendly administration. Competition is not really necessary. And the conclusion, my speech should be seen as an invitation to a deeper analysis and as a presentation of the point of view of the private sector. My objective will be achieved when each party will be able to better understand the needs of the other one.